Good afternoon, everyone, and welcome to our webinar this afternoon about services connected to immovable property. It's introducing the new rules for 2017. And today we'll be talking about the new rules. First of all, we'll talk about the EU VAT legislation and place supply of services, just as a background for those that aren't fully aware of how the place supply of services works. We'll also be talking about why the rules have changed recently, or why they've been reintroduced. We'll talk about what are the changes, why it matters for businesses. We'll run through some examples so we can apply the legislation to some examples. We'll have some closing remarks, and then we'll have an opportunity at the end, about 15 minutes or so, to answer your questions. And you can ask questions by going into the questions section on the webinar interface. Okay, so for those of you that may not be fully conversant in the VAT language, we often talk about place of supply, or POS, for abbreviation purposes. This is basically where VAT is accountable. So wherever the place of supply is where you have to account for VAT. If the place of supply is the UK, then you have to consider the UK VAT rules. If the place of supply is outside of the UK, perhaps in the EU, then you have to apply the EU VAT rules. Similarly, if the place of supply is outside of the EU, then there's no UK or EU VAT to consider, but you may have to consider the local rules of that country. So whether they apply a VAT system or a GST system or something similar, you may have to consider those types of rules. The place of supply rules can also be dependent on the status of the recipient of the services that are being provided. So when we say status, we mean whether they are a business or acting as a business, as a taxable business, or whether they are a non-taxable business, such as a private individual, for example. And there are also, quite importantly, different rules for place of supply of services and goods. So today we're just talking about services, but if you are considering goods as well, there will be different place of supply rules for goods. And also the nature of the service will determine the VAT treatment as well, which is what we'll be talking about today. So just a quick overview of EU VAT legislation. So the main EU VAT legislation is found in Council Directive 2006/112/EC, also known as the VAT Directive or the Principal VAT Directive or the Directive. But basically it consolidates the basis of the VAT system in the EU, and it's the governing legislation which most countries will interpret and use as their own domestic legislation. It's a recast of the 6th Directive, which was established back in 1977. In the UK, since most of our attendees here today are from the UK, the principal legislation in the UK is the VAT Act 1994, which implements those EU rules. The VAT Directive was introduced basically in 2010. The new rules, place of supply rules, were adopted as part of the VAT package. There were several changes that were phased in from 2010 to 2015. So basically the new place of supply rules were introduced in 2010. There were new rules introduced in 2011 for admission to events. In 2013 there were new rules for long-term hire of means of transport, and recently in 2015 there were new rules for telecommunication, radio and electronically supplied services. You may have heard that referred to as the mini one-stop shop rules, or the MOS rules. So for the general rule for the place of supply of services is kind of the default position when we're talking about the place of supply. The general rule depends on whether it's a B2B service or a B2C service, but if we're talking about B2B services, the place of supply is where the business customer is established, and that means that the VAT rules will be determined based on where that customer is established. So that's found under Article 44 of the VAT Directive. Basically that means that where these rules fall under that article, VAT is accounted for by the customer applying the reverse charge, and we'll talk about the reverse charge procedure in a bit more detail in the following slides. When the service is subject to Article 44, there's normally no requirement for the supplier to be registered in that other member state, but there are specific invoicing and reporting requirements in order to qualify for one of those services. For B2C services, the place of supply is where the supplier is established, and this can be found in Article 45 of the VAT Directive. Now, there are some exceptions to the general rules found in Article 44 and 45. We've put some examples up there. This list is not exhaustive, and it can depend on whether it's B2B or B2C. So we've mentioned short-term hire means of transport. There's also passenger transport, subject to where the transport takes place. There's also things like restaurant and catering services, so the place of supply is where the restaurant and catering services are physically carried out. And the most important one, which we'll be talking about today, is services connected to immovable property. And the place of supply is where that property is located. Now, the legislation for services connected to immovable property is found in Article 47 of the VAT Directive, and this rule provides that the place of supply of services connected with immovable property shall be where that immovable property is located. And here's the actual legislation, and you can see by reading through that it does specifically mention some types of service providers. So it talks about service experts and estate agents. It talks about granting of rights to use immovable property, and that can be particularly relevant for some of our attendees today, such as event companies where they're granting space-only exhibition space. It also mentions construction work, services of architects, on-site supervision, but there are more examples which we'll talk about later through the presentation. Now we have an example. So we talked about architects in Article 47. So, for example, if there is a UK architect which draws up plans for a building in Madrid, then the place of supply is Spain, because that's where the immovable property is located. The rules are in place to ensure the VAT is collected or taxed where the services are essentially consumed. And you must note that Article 47 is actually a particular rule and not just an exception to the general rule. The difference being that exception rules must be strictly interpreted. So exception rules will relate to things like exemptions from VAT or reduced VAT rates, for example. Article 47, being a particular rule, should be applied on an objective basis. So therefore you need to think about exactly what you're doing and the purpose of the rule. This can lead to some uncertainty in certain situations, but hopefully through today's presentation we'll make things a bit more clear as to whether your services are affected and how to treat them for VAT purposes. So why did the VAT rules change? There's a few reasons. Article 47 always existed, the rules being that the services connected to immovable property are subject to VAT in the place where the property is located. However, EU countries always had different interpretation of the rules, and this led to confusion, lack of clarity amongst EU member states, and managing your VAT obligations as a business across the EU meant it was very complicated because you weren't quite sure whether one country applies the same rule as the next. The new rules provide more consistency, effectiveness and certainty. So as long as you can follow the rules correctly, you should be more certain about the VAT treatment and manage your risk more efficiently. The new rules also have binding and direct effect, which means they shall apply, they must apply to your particular situation, and these have effect as of the 1st of January 2017, which is why we're talking about them at the moment. I'll hand over to Rob Jannering, who's going to talk about what exactly are the changes.
Hi, thanks for that, Loz. So what I'm going to do is just talk through some of the technical aspects of the changes now to see where the legislation is, which will be really useful for when we refer to the examples later on. So, as Loz stated, Article 47 isn't a new rule, it's always been around, but as you can see in the slide, it was just that short bit of writing which didn't give a great deal of guidance. So the EU has been rolling out in a constant basis new legislation and updates that legislation all the time to help taxpayers get the right result more often than not. Where the changes for Article 47 started were actually some implementing regulations published in October 2013, and actually these were focused on the MOS changes that we talked about at the beginning. However, what was also included within those implemented regulations was a new way to help ensure uniform treatment of the immovable property situation. And the way they achieved this was by having a concept basically defining what immovable property was and then specifying how that was linked to a service and what that connection had to be to make the service connected to it. It was noted, obviously these changes were published in 2013, but everyone was aware that Article 47, it was an objective rule, so it's probably being interpreted in lots of different ways across lots of different member states. What this meant was that member states were going to have to take some time to be able to implement it and get prepared. So, even though the new implementing regulation was published at the end of 2013, they weren't going to have effect until the 1st of January 2017. And the reason for this was to give member states the opportunity to review what the new legislation said, take some steps to think about how that interacted with its existing rules, its existing interpretation of Article 47, and then also get them put into the national legislation and guidance if they wanted that to be the case. And it's worth also mentioning that in October 2015, there was guidance published on the new rules. So this is not something that always happens, but the European Commission recognised that Article 47 rules are difficult and they're complex and they're objective. So a large guidance document was published, and it was it's not legally binding on the member states, but it goes into a great deal of detail about how the new rules should be interpreted and also how they should be applied in certain situations. So although it's not legally binding, which is something the EU Commission will always say when it produces guidance, it is a very good guide and a reference to help businesses. So what are the main changes that have happened and have been implemented in the implementing regulations? Well, one of the first things we now have is what we refer to as a functional test. And this is relevant where you've got an installation happening and the property, and you're thinking about, is that installation integral to the building? For example, in the absence of that equipment, could the building be used for the function for which it was designed before? We've also got the application of the word integral as well, and that being subjective. So what the change is giving is more clarity. It's saying that you need to be able to function. Can the building function without the equipment? If it can't function without the equipment, does it still make it immovable property? And what we'll look at in the next couple of slides is how that can be interpreted in different ways for different circumstances. Another change that's happened is there's been clarification around the meaning of what permanently installed means. And the interesting thing is it doesn't always mean permanently. which is kind of confusing, but also we'll talk through the reasons why. What the implementing regulations say is that there has to be a specific purpose for that item in the building or the construction it's involved with, and that it must be intended to last or remain unchanged to be clarified as being permanently installed. And if you think about that, installed items may not be meant to last forever. They might have a lifespan on them. They might need to be replaced. However, if they've got a specific purpose in the building and you're not going to change them once it is installed, that is going to make it permanent. And that's really important because that's a very objective point of view again on how items are used and how they're going to be, their lifespan and they're developed, especially so as new construction techniques are evolved and different ways of buildings happen. And the last significant change we've seen that's come in is more clarification around the meaning of destroying or altering. Like we've always said, it's an objective piece of legislation, and destroying and altering meant it could be open to different interpretations. So what we're trying to do is get more certainty on it and get a uniform view taken across it. So destroying is now being clarified to be said it means damaged beyond repair. So the item can't be used anymore, in effect. If it can be repaired and put back into use, then it's not destroyed. Altering means something is changed, but it excludes minor damage to an item. So what that means is, under the previous interpretation, you could have damage, could have been when you remove bolts that have put something into the floor. So just by the fact of pulling the bolts out of the ground, you might have damaged the ground. That's no longer the case. And also minor damage, you might do a bit of damage, maybe the bolts coming out of the floor, but that doesn't count to be an alteration of the building. And again, this just gives us more certainty and greater assistance in deciding when we're making a service connected with immovable property or not. So just keeping those changes in mind, the key questions we need to ask ourselves when we are looking at whether we're providing a service that is connected with immovable property or not, there are two, and these are as follows. The first question is, does the service relate to a property that can qualify as immovable property? So we're asking, is immovable property involved, and we need to look at the definition of that. And then if we decide, yes, immovable property is in play, the second question is, does the service we are providing, is there a sufficient connection between that service and the immovable property to connect the two together? And it's only if we can answer yes to both of those questions, then we've got a service connected with immovable property, and we need to start to consider the Article 47 rules. So what we're going to go through now is just some of the actual legislation that was put into place and think about how that interacts with what we're talking about. So we said the first question we need to answer is the item immovable property? And this is covered by Article 31B, and it specifically sets out 4 different categories giving more detail, which helps you distinguish between immovable property and tangible movable goods. And what we're going to do now is just look at those 4 different examples and just think about what they mean. So the first one says an immovable property will be any specific part of the earth on or below its surface over which title and possession can be created. So what we have here is a statement with 2 tests in it. So you've got to have a specific part of the earth. So that means you've identified somewhere and you can put your hand on it or place it on a map. If you can't put it down somewhere specific, you don't meet the first test. And then the second challenge is to say, can title and possession be taken over it? Now, there's lots of different interpretations of title and possession. different EU member states have different readings and writings of the legislation. So sometimes it's title and possession, sometimes it's title or possession. So what we look at here is the economic reality of what's happening. And so if someone economically can have that land and they can exploit it, that's probably going to meet the test. The second paragraph within Article 13b, it says any building or construction fixed to or in the ground or below sea level which cannot easily be dismantled or moved is immovable property. And again, what we have here is a two-test question. So the first one is saying it's got to be fixed to or in the ground. And then the second question is it cannot be easily dismantled or moved. Now the second part of that is probably the key bit, and the word easily is a very subjective point of view there. What you need to think about when you're easily, it's subjective and it can be viewed in lots of different ways. For example, you need to think about, do I need professional skills to remove the item? Is there a need to dismantle it? Or if I wanted to dismantle it, would it actually end up destroying or altering the item or change its value significantly? So again, like we said at the beginning, it's an objective test, but this helps you to determine when it's immovable property or not. The third section, the third paragraph, it says immovable property is any item that's been installed and makes up an integral part of a building or construction without which the building or construction is incomplete. And it gives an example such as doors, windows, roof, staircase and lift. The key phrase here, the key word here is integral, and what the legislation is saying is that without this item the building's incomplete, and in the absence of it would the nature of the building change. So thinking about it, it means is the part integral to the building if it leads to destroying or altering it if it's taken out. And that leads us on to the fourth part, which is any item, equipment or machine permanently installed in a building which cannot be moved without destroying or altering that building or construction. And what this means is that the last paragraph is interesting because in effect you can have an item, the equipment or machinery, and the fact that equipment or machinery is used specifically doesn't preclude other items being involved, which are not actually connected or integral to a building, but the fact that they destroy or alter that building when they are removed can make them become connected to the building. So there is a certain amount of interaction between the different definitions of immovable property. But these are the four paragraphs we look at to answer the first question, do we have immovable property? Having answered that question, the next stage is to go on and say, well, is the service I'm going to be providing connected to that immovable property? And so this is covered by a different part of the legislation. It's Article 31A, and again this was brought in with the new implementing regulations, but it's here to help us identify when the services are connected with immovable property. And just like 13B, there are several key parts of the article that help you understand how to interpret the new rules and how to use them to make sure you get the right VAT treatment for your services. Article 31A.1 is the first part we focus on, and this is guidance on what is qualifying as a connected service. We then have 31A.2, which gives a list of examples of all services which are connected with immovable property. So this is the EU writing legislation that says if you're doing this, it is connected with immovable property. And then in quite a logical step, Article 31A.3 says that this is a list of services not considered to be connected with immovable property. And so you can then look through that list and say, well, if I'm in that list, I know that it's not connected. Now, just looking at 31A.1 first, this is setting out and giving the background really to when you have a sufficiently direct connection with Immovable Property. And it says there are basically two things to think about. The first one is the service derived from Immovable Property? And does that property make up a constituent part of the service, and is it central and essential to it? And then it's got another paragraph that says when the services are provided to or directed towards an immovable property, is that the object of the legal or physical alteration of that property? So these are both very subjective, but what you need to remember is that you're looking at each case, each transaction on a case-by-case basis. So in effect, the question to ask here is, if this immovable property wasn't here, could I still provide my service? Or do I need the immovable property to provide the service? And that is basically the key question you're asking yourself. What is really useful though is obviously Articles 31A, 2 and 3, because it gives you specific examples of what is and what isn't connected with immovable property. What's also very useful is the way that the legislation should be interpreted, and this is set out in the guidance, so it helps everybody to understand the right way that they should go about understanding the rules and reaching the right VAT treatment position. So it says in the first instance, actually Article 31A2 is the one that should be reviewed. So you look at that. This is the list of examples where the service definitely is connected. You go through all of them, and if your service is in that, you say, I know my service is connected to immovable property. If you can't find your service in that list, you go to Article 31A3, and you see if it is specifically excluded from the legislation. And again, if it's in that list, you've got certainty and know what to do. And if you can't find your service in either of those lists, then it's necessary to go back to Article 31A, 1, and review it to see if the service fits any of the criteria laid down there. And the really good thing about the way you interpret this legislation is that you can go through and check that it is in there, you can check it's not in there, and then your final step, and only really as a fallback, is seeing, do I need to objectively check it against the criteria in the legislation? And hopefully that will make it easier for businesses to understand when a service is connected or not connected, and by being able to tally it directly back to a piece of legislation, they are unlikely to get challenged on it. To give a flavour of what services are listed as being connected, there are actually 17 different services connected, listed in that bit of legislation. We don't have time today to go through every single one of them, but we've listed out below some of the key ones. So the drawing up of plans for a building, when there's a particular plot or land has been identified, the provision of on-site supervision or security services, the maintenance, renovation and repair of a building, and again there we've got some examples, property management other than portfolio of management of investments, and the provision of accommodation in the hotel sector. Like I said, that list we've got on the slides isn't exhausted, there are more. That gives you some of the key ones. And then Article 31A3, services not connected. Again, there are 8 different services listed here. Again, a flavour of them is storage of goods in an immovable property. If no specific part of the immovable property is assigned for the exclusive use of the customer, then that is not a connected service. The provision of advertising, even if it involves the use of immovable property. So for example, maybe an advert being on the side of a building or inside of a football stadium on the side of a stand, that wouldn't count. It falls back to advertising, which is a general rule service. And then this will be relevant to some people on the webinar, the provision of a stand location at a fair or exhibition site. when you also get other items alongside it, such as machines, cable laying, insurance, and advertising. So hopefully that talk through the legislation gives you an idea of how to interpret it and how it's set out. What we'll talk about now, and I'll pass back to Loz, is why all of these rules matter to businesses.
Thanks, Rob. So, yeah, why does it matter to you as a business? What do these new rules actually mean? Well, Article 47 is important because it can create a number of additional compliance obligations for businesses. So at the moment, most businesses will probably provide services which are subject to the general rule, which is fairly straightforward. The customer in the other country accounts for the VAT. But Article 47, if that means that you now as a supplier have to account for VAT in a different country, then you have some additional VAT things to think about. So normally where Article 44 applies, you don't have to register in that other country, but where Article 47 applies, you may have a registration obligation. So if the place of supply is not in the same country as where the supplier is established, then you need to consider the registration obligation for you as a business. Most EU countries have a nil VAT registration threshold, so that means even if you provide an Article 47 service, and it's even for very, very small amounts, you will likely have to still consider accounting for VAT because of this nil threshold in most European countries. If you are required to register, you have to start thinking about the local VAT rules. So that would mean local VAT returns, and there will also be other compliance obligations potentially depending on the member state involved, but that could include thinking about things such as tax points, how to file the VAT returns, the deadlines, the payments. Can you speak the language in which the place of supply is in that country? Sometimes if you're asking for a repayment of VAT in that country through that local VAT registration, you may be automatically audited. So all of these things you may have to consider if you fall under Article 47 and are required to register in that country. We've mentioned something called the reverse charge a few times. This is a particular process whereby instead of the supplier accounting and charging for VAT to the customer, actually the customer or the recipient of those services can account for VAT on behalf of the supplier. It's really a simplification that was introduced by the EU to avoid businesses from having to register in multiple countries. So really the purpose is that the business customer receiving the services can basically self-assess or self-account for the VAT on behalf of the supplier, as long as that business is a fully taxable business, of course. You also have to consider the extended reverse charge and whether it applies to services connected with immovable property. Normally, in most EU countries, you find that it's being introduced or has been introduced over the last few years, but there are certain requirements for that to take place, and it's covered in Article 194 of the directive, the extended reverse charge, or the domestic reverse charge as it's also referred to sometimes. But one of the requirements is usually that you are a non-resident in that country for the extended reverse charge to apply. And there are some other requirements such as the recipient of those services being registered for VAT in that country, and in some cases the recipient needs to be established in that country as well. So where the extended reverse charge does apply, it shifts the obligation to account for the VAT onto the recipient, and this means that supplier no longer has to obtain a local VAT registration nor file VAT returns or worry about any of the additional reporting obligations that we mentioned previously. But as I mentioned, the application of the extended reverse charge can be dependent on the country in question. So when you're looking at these sorts of services and you realise that your place of supply is in another EU member state, you'll have to consider whether the extended reverse charge is applicable or not to that type of service and to the situation. So thinking about it, no, not having to register for VAT in another EU country sounds like a fairly good thing, and you won't have the compliance costs. It's normally an advantage, but if so it also reduces risk as well, actually, and compliance costs. But if you do incur VAT in the process of providing those services related to immovable property, then you won't be able to recover that VAT you've incurred via a local VAT registration. So how do you go about recovering that VAT? Well, they can only be recovered by an overseas refund claim, an EU refund claim, or 13th directive claim for non-EU businesses. Unfortunately, these types of refund claims can be quite time-consuming. It can take several months, and in some cases several years, to get the VAT you've incurred back. So it can actually be an advantage to register, because you may be able to get your VAT back sooner. So we've talked about the rules, how they are implemented and how they apply. We're going to go through some examples now. I think we've got 4 examples to walk through, and how each situation is treated for VAT purposes under these clarified rules. So we've used the EU Commission guidance on these, but you must remember that this is just practical information on how to interpret the rules, and it's not legally binding. So please don't take any of these examples as formal advice. Always recommend seeking specific advice before getting any VAT registrations or anything else like that. So the first example we're going to look at is architectural services. I think we have a few architectural businesses on the webinar today. In this particular example, the architect is established in the UK, and he is supplying services to a customer established in France. The architect's initial work involves developing conceptual designs and working up outline drawings. The customer then asks the architect to apply those general designs to a specific piece of land he's just purchased in Spain, and the architect then does this and supplies them to the customer, but the property is not completed for whatever reason. So what are the VAT issues to consider in this particular scenario? Well, at first, the architect is not aware of there being a possible site for the property. So looking through the legislation that Rob has just talked through, Article 13 B and 31A, we look through the list of examples, and under Article 31A 3A, which is the specifically excluded services, the drawing up of plans for a building or parts of a building, if not designated for a particular plot of land, is excluded from the suppliers connected to immovable property, and therefore it would revert back to the general rule, Article 44 service. So that's the general rule, B2B supply, and therefore the recipient of those services would account for VAT in their own country. So nothing to worry about at the moment for this architect. However, the architect then becomes aware that there is a site in question. So then we have to reconsider the VAT rules for it. So we have to look at Article 13B. Is it immovable property that we're talking about? So any specific part of the earth on or below its surface over which title and possession can be created. Yes, we're talking about immovable property here. We're talking about a physical, tangible property. And then we look at Article 31A 2A is the actual item in that list of included services. So is this service connected? The drawing up of plans for a building or parts of a building designated for a particular plot of land, regardless of whether or not the building is erected. So basically we're talking about exactly the same situation here. This architect now knows that the plans are going to be for a specific building in Spain, and therefore we have to look at Article 47 of the EU VAT Directive, and the place to supply is where that building is. It doesn't matter that the building is never constructed. The actual service is connected with immovable property. And a need to register is created because the reverse charge doesn't apply in this instance. So that's just one example of how the services that initially may not be treated as connected with immovable property can change, and having a look through the legislation how to apply it in a scenario like that. I'll pass over to Rob, who will talk about engineering services.
Okay, thanks for that. So yeah, just a couple more examples to go through to help you just understand how the rules work and what they mean. So in this example, we've got a Spanish business who's been engaged by its customer to maintain and repair, inspect and supervise some machines and equipment it's sold. Its customer is a UK VAT-registered business, and all of the machines it's going to look after can be found in the UK, permanently fixed to the floor of the building where they are. What it's worth knowing is that the Spanish supplier has said it'll complete its service by sometimes attending the site, so employees flying over and actually looking at the machines, being able to touch them and review them. But then at other times it's going to perform its services remotely, because it's going to put IT equipment into the machines, and that will enable it to monitor without having to always visit. So that's the background. What are the VAT issues to consider? So the first thing is we need to know if it's immovable property. Well, the machinery is affixed to a property. It can't be removed without destroying or altering the building. So that is immovable property, and it's located in the UK. The next question then is the service connected with it? Well, it would suggest Article 31A2N specifically says, yes, if you're carrying out work that is maintaining or upgrading or making sure there's still work to machinery, that is connected. And the guidance also suggests that the work carried out remotely can be connected with the immovable property as well. So even when they're doing the IT services and they're just looking at their computer still based in Spain, the service is connected with the property in the UK. So we know all of the service is subject to UK VAT. However, a need to register is not created because HMRC apply the reverse charge mechanism, and this applies in the UK specifically when you have a non-established business making the supply to a UK VAT registered business. So in this example, we've got a Spanish supplier making remote supplies to a UK business with the property in the UK. Luckily, they don't have to register for VAT, reverse charge to account for it. The next example we have is to do with construction services. The background for this involves a UK business. They've been asked to supply and install some lifts and escalators into a shopping centre in Sweden. And in this instance, the customer is a US business. It must be the owner of the shopping centre in Sweden, and they are not registered for VAT in Sweden. So the question we need to ask ourselves again, what do we need to consider? Are the items going to be installed? Are they going to make up an integral part of the building located in Sweden? And can they not be removed without destroying or altering the building? If we look at it objectively, when you are putting the escalators in and you're putting the lifts in, more often than not there is no intention to remove them. We could confirm that by looking at the situation here of the buildings envisaged to be used for a long time into the future. Then yes, we can say that it is immovable property. And then the second thing is the service connected to it? Well, actually, yes, in 31A2M, it says when you are installing something that's integral to a building, it is connected to immovable property. So Article 47 applies. The next question we then look at is there a need to register? Who has to account for the VAT? Well, in Sweden, there is a reverse charge, but it doesn't apply when you've got a non-established business and a non-VAT registered business. So the supplier here from the UK will need to obtain a Swedish VAT registration, and he will need to charge Swedish VAT when he makes that supply. And the final example we have is that of survey and analytical services. So in this example, we've got a UK business, and they are going to put little sensors underneath the car parking space of an airport car park in France. And the reason for doing this is that the device will monitor when the parking space is being used, and then that information can be sent back to the UK. He can make weekly reports, and the people using the airport space will have a much better understanding of when it's being used, and they might use that information to work out, are they getting the right revenue, do they need to build more parking space, etc., etc. So what are the VAT issues to consider here? So the first one is, are the sensor devices immovable property? Well, unsurprisingly, this kind of service doesn't fall under Article 31A2 or 3, which tells us a service that is or isn't connected to immovable property. So that means we fall back to look at Article 31A1. And this says, services connected with immovable property shall only include those services that have sufficiently direct connection with that property. And so what we're asked to do here is say, is there a substance and is there a real subjective connection between the sensors and the immovable property? And the logic we would probably follow through is to say, are the services derived from immovable property? Well, if we didn't have the car park, and if they were not embedded into that car park, the service couldn't be provided, and the customer wants to understand more about that immovable property. So we ask ourselves, does the property make up a constituent element of the service, and is it central and essential to it? And the answer is, it's highly likely that the services are connected to the immovable property, and on that basis there is a place of supply where the car park's located. That's all the examples. As we said before, if you've got any questions, please send them through to us. Loz is just going to wrap up now, but if you've got any questions, please send them through now and we'll talk about them at the end.
Okay, so just a few final remarks then. I know it's been a fairly long slog, we're almost at the end now, but no webinar would be complete at the moment without a quick nod to Brexit and what's going to happen in a few years' time once we're out of the EU. Well, we don't know for sure. It's unlikely that anything would change drastically in the short term. We think the UK rules will likely remain unchanged in relation to services related to immovable property and probably VAT in general. We look at a couple of other countries like Norway and Switzerland, and they have rules that largely mirror the EU rules, so we don't think there's going to be any significant change for the time being. Looking outwards, so for UK businesses that may have to do business in the EU, it may be more onerous once we're outside of the EU, so that may include appointing fiscal representation where VAT registrations are required, and also putting in place bank guarantees as well. So at the moment, because we're part of the EU, that isn't required, but for any non-EU business currently doing trade into the EU, and it includes VAT, some countries do apply these fiscal rep and bank guarantee rules. So it's something just to consider as and when we leave the EU. So some key points to take away. First question to ask yourself when looking at these sorts of transactions, is it immovable property? Look through Article 13b. Are the services connected? Again, we have to look at the relevant legislation, looking at Article 31a. Determine where the place of supply is. Is it in that particular country? Is it where I'm established? Who's liable to account for VAT? Is it me as a supplier, or will the extended reverse charge apply, and therefore my customer can account for VAT on my behalf? If I do need to register, what are my compliance obligations? How often do I need to file VAT returns? How do I make payments? How do I file my returns? Should I check my contractual terms for any VAT exposures? Then probably should do, because with VAT rates up to 27% in the EU, then if you get it wrong, it could be quite costly. will I incur VAT, and if so, can I recover that VAT? That's another important question. So normally VAT is fully recoverable as a taxable business, but how do you recover that VAT? And as always, if you are in any doubt at all, we always recommend to seek advice. As I mentioned, VAT can be quite an expensive tax to get wrong, so we're always at the end of the phone to help you if you've got any questions at all. So we have about 5 or 10 minutes left just to go through any questions you have. Rob, do we have any questions at the moment come through?
Hi. So yes, we've got a few questions come through. So I will start going through them now. So the first one is asking a question about the EU refunds. So we talked about where the reverse charge applies, you don't need to register. Obviously that can cause a problem because you might incur VAT on your costs in a certain country, but the normal way to get them back is to put them through the VAT return, but if the reverse charge applies, there's no VAT return to do it. So the way to recover those VAT costs is to do a refund directive claim. There are different ones for countries in the EU and those outside of the EU. And so in response to the question, can a US firm get an EU refund? The answer is in some countries yes, and in some countries no. The key deciding point is reciprocal rights. So if what the EU member state will do is say, the person from the other country, would they give for example, a UK business a refund of VAT? And if they do, then the UK will probably give a refund of that to that other person. Now the US is different because it doesn't have a VAT system. And so some EU countries have said, because there's no VAT system, we can't have an equivalent reciprocal arrangement. And so, yes, we'll just repay the VAT. But some other countries say, no, because there's no VAT system, we're not going to give US firms back their VAT either. So the answer to the question is yes sometimes and no sometimes, but this is why it's so important to work that out in advance. Another question we've got is there a central place to look up the reverse charge rules in EU countries? As far as we're aware, there isn't. And as we said, the rules are different in every single country, and they can change from year to year. The EU's made really good steps forward. It now publishes a lot of information on its website around rates, around place of supply rules, around how to interpret the legislation. Unfortunately, each individual EU member state has the ability to set its own rules on when the reverse charge applies and what the conditions for that reverse charge are. So there isn't a central database of that can be relied on. If someone did have a question about it, I would advise them to seek some professional advice, either via their local advisor or elsewhere. One more question we've got here. If a company provides architectural services to a client located in the UK, and that service is then used for land outside the EU, do you charge VAT to the client in the UK? The answer to the question is, I'm sorry, it's just slid down my question page, I'll go back to it. You have to look at, is it immovable property, and is it a service connected to that? So if the architect's been told, build the building on the land, and the land's outside of the EU, here's a map of it, then you've got your immovable property, and the service is connected to it because it's saying, I want you to design me something that's going to sit on this land. So if that land is outside of the EU, then you don't need to charge any UK VAT. What you do need to do is think about, are there any local rules in that non-EU country that are going to require me to register? And in thinking about that, a lot of non-EU countries apply very similar rules to the Article 47 we've been talking about today. So it's likely that when a supply is made relating to that immovable property, you might have a need to register in that non-EU country. What I would say is you need to go and get specific advice on that, because outside of the EU, each country has its own ability to set its own EU VAT rules. And so looking specifically, can you register? Do I need to register? Can I shift it? All of those questions need to be answered to make sure that you get your compliance right. Another question, how do you discern whether a VAT registration is required for suppliers to remove immovable property? For example, assuming the customer is locally VAT registered, how do you discern whether the reverse charge can be applied, and what's the split around countries allowing a reverse charge and not? So generally, whether the reverse charge applies or not is based on is the customer's status. So is the customer established in the country where the immovable property is? Is that customer registered for VAT in that country? And does it have a right to be registered for VAT in that country? And also, what other activities is it taking place in that country? So there are 4 general rules to look at, and they do differ across every country. I would say, off the top of my head, a lot of countries do apply a reverse charge. And so there is often an opportunity to not have to have a VAT registration. Like I said, though, the key point is to look at what your customer's status is, and then that can help you define whether you need the registration or not. One final question we've got here is, how is portfolio management for investment defined? And you're right, and is that excluded from the land-related supplies? So yes, it is. I believe there's a definition of it within the guidance, but the way you would exclude it, and the reason it's excluded, is that generally where you've got a portfolio and you're investing in it, you're holding shares in a vehicle, so a legal entity, and you are holding those shares. And because you're holding the shares, and your service is more connected with, should I invest in property in this country, or should I move the shares to another kind of asset class, it's excluded because you're not directly connected with that property, so you're not doing something to the property, you're not installing something in it, it's not got enough of a link between the service and the immovable property. It seemed to be slightly more passive, the holding of the shares and the investment, and that's why it's excluded from Article 47.
Okay, there's also been a couple of questions about will the slides be available after the webinar. Yes, they will be available. So for everyone that's signed up and attended, we've also made a video recording of this webinar, so you can go back and watch anytime you like. But the slides will also be available as well. So we're now at the end of the webinar. I'd like to thank everyone for attending. Obviously, if you do have any questions or concerns, feel free to get in touch with us for a no obligation consultation, and we're more than happy to have a discussion with you about your particular needs and questions. Okay, thanks very much.